Hello friends, today we will discuss section 43 and 44 of the Indian Evidence Act. For your convenience, the section 43 is on your screen. Read with me. Judgments, etc., other than those mentioned in sections 40, 41 and 42 when relevant. So in section 40, 41 and 42, there are some mentions. Those sections deal with some kind of judgments which are relevant. Now, other judgments which are not covered under section 40, 41 and 42, when they will become relevant. Judgments, orders or decrees other than those mentioned in sections 40, 41 and 42 are irrelevant. Judgments, orders or decrees other than those which are mentioned in 40, 41 and 42 are irrelevant unless the existence of such judgment, order or decree is a fact in issue. That judgment other than those which are mentioned in 40, 41 or 42 are irrelevant unless and until the judgment, order or decree is a fact in issue or is relevant under some other provisions of this act. To understand this section better, let us discuss the illustrations. A and B separately sue C for a libel which reflects upon each of them. C in each case says that the matter alleged to be libelous is true and the circumstances are such that it is probably true in each case or in neither. A obtains decree against C for damages on the ground that C failed to make out his jurisdiction. The fact is relevant as between B and C. This fact will be relevant between B and C. The next one, A prosecutes B for adultery with C, A's wife. A prosecutes B for adultery with C, C is A's wife. B denies that C is A's wife, but the court convicts B of adultery. Afterwards, C is prosecuted for bigamy in marrying B during A's lifetime. C says that she never was A's wife. The judgment against B is irrelevant as against C. So, first, there was a case between A and B where A's allegation that B did some adultery with C, that means A's wife. B denied that C is A's wife, but the court convicts B for adultery. Afterwards, C is prosecuted for bigamy in marrying B during A's lifetime. C says that she never was A's wife. In the later case, C also denied that she never was A's wife. The judgment against B is irrelevant as against C. When B was convicted for adultery, that means in that case, court presumed that C is A's wife and B had some illicit relation with C. Based on that ground, court convicted B. Now when in a later case against C for bigamy, and C claimed that she was never the wife of A, In this later case, the judgment in earlier case against B will not be a relevant against C. In the later case, it cannot be said that in the earlier case, court held that C was A's wife and C had extramarital affairs with B. That will not be utilized, that will not be relevant in the later case against C. Next, A prosecutes B for stealing a cow from him. A prosecutes B for stealing a cow from him. B is convicted. A afterwards sues C for the cow which B had sold to him before his conviction. A's between A and C, the judgment against B is irrelevant. That means, first, A lodged a case against B for stealing his cow. And in this case, B is convicted. So, it was established that B had stolen the cow of A. That's why B was convicted. Later, A filed case against C because before B's conviction, B sold the cow to C. Now, in the later case between A and C, the judgment of earlier case in which the court held that B had stolen the cow of A will be irrelevant. Now, next illustration. A has obtained a decree for possession of land against B. C, B's son, murders A in consequence. The existence of the judgment is relevant as showing motive for a crime. Earlier illustrations was where the earlier judgment will be irrelevant. Now we are discussing where it will be relevant. A got a decree for a particular land against B and became the owner. A's right title interest was established by virtue of that decree. As A got the decree against B, B's son got angry, and for retaliation, B's son murdered A. Here, the earlier judgment where A got the decree against B, and by that decree his right title interest was affirmed in a particular land, on a particular land against B, and out of that anger C murdered A. So the earlier case shows the motive for the later case, that means the crime. So the decree of the earlier case will be relevant in the later case. Next, A is charged with theft and with having been previously convicted of theft. The previous conviction is relevant as a fact in issue. A is charged with theft and with having been previously convicted of theft. He committed similar crime earlier also. He is a habitual in these types of crime. So the previous conviction is relevant as a fact in issue. Next, A is tried for murder of B. The fact that B prosecuted A for libel and that A was convicted and sentenced is relevant under section 8 as showing the motive for the fact in issue. It is showing the motive of the fact in issue under section 8 I discussed earlier. A is tried for murder of B. The fact that B prosecuted A, B earlier in an earlier case prosecuted A for libel and A was convicted and sentenced. Out of that anger, in retaliation after release from jail, A murdered B. So the earlier judgment by which A was convicted is showing the motive of the fact in issue, the murder of B by A. So it will be relevant. The next, fraud or collusion in obtaining judgment or incompetency of court may be proved. Any party to a suit, it is on your screen. Any party to a suit or other proceeding may show that any judgment, order or decree which is relevant under 40, 41 or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it. Not competent to deliver it. How the court is not competent? Is it academically not competent? No. Either on the basis of territorial jurisdiction or pecuniary jurisdiction, or if there is any specific jurisdiction. If the court passes any order beyond its jurisdiction, so it is not competent to pass that order, to entertain such cases. So was delivered by a court not competent to deliver it, or was obtained by fraud or collusion. Collusion means both the parties have nexus, and with this nexus they filed something in court, and with that nexus they obtained some order from the court, or they practiced some fraud with the court to get such order. So these may be proved. So any party to a suit or other proceeding may show that any judgment, order or decree which is relevant under section 40, 41 or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it, or was obtained by fraud or collusion. So today in this very small session we discussed section 43 and 44. In the next episode I will start expert opinion, which is very important, very important and very much interesting also. Till then, if you like my video episodes on these legal matters, I will humbly request you to kindly subscribe my channel and share this channel with your friends who are interested in similar matters. And if you have any suggestion, if you want to convey anything to me, feel free to email me or call me or just make comments. Till then, thank you. Stay blessed.